The order on the remedies discovery and briefing in the XRP lawsuit was signed by Judge Annalisa. The United States Securities and Exchange Commission and Ripple Labs are currently engaged in a legal battle, and Judge Annalisa has devised a timetable for the identification of potential solutions and the submission of briefs in the case. After Ripple and the United States Securities and Exchange Commission came to an agreement the week prior to move forward with remedial discovery and briefing involving institutional sales and other pending claims, the decision to take this step was made. The deadlines for the discovery of the remedies and the briefing on those remedies have been set by Judge Torres in the XRP litigation. According to a document that was submitted to the court at the end of the 13th of November, Judge Annalisa Torres has established a time frame for the discovery process as well as a briefing schedule for potential remedies. After conducting an in-depth analysis of a letter that was sent by Ripple and the United States Securities and Exchange Commission and having it dated November 9, the judge assigned an order on the briefing for remedies, discovery, and briefing involving institutional sales and other pending claims. The letter had the date of November 9 on its envelope. The parties are required to have completed all of the discovery work relevant to viable remedies by the 12th of February in the year 2024. The SEC will submit its brief for Section 5 violations related to its institutional sales of XRP and other components by the 13th of March. The next thing that will need to happen is that Ripple, the defendant, will have to file its opposition by the 12th of April. The plaintiff will be given one additional week to submit their answer to Ripple by the 29th of April. This extension was granted at Ripple's request. The SEC brief on potential remedies is due just 9 days before the Wave of Innovation 2024 XRP Gold Coast Conference, according to a lawyer who advocates for XRP named Bill Morgan. John Deaton, an attorney who represents thousands of XRP investors, is scheduled to make an appearance at the conference as a keynote speaker. Deaton will also be present at the conference. He remarked that the community might anticipate lots of new insights into the XRP case, particularly with remedies findings should the parties opt to resolve the matter before it goes to trial. He was referring to the discovery that Remedy had made. According to the attorney, Jeremy Hogan, a definitive ruling might be rendered in the month of July, given that the last briefs could be presented in the month of April. He asserted that because the SEC decided to drop the allegations against Ripple executives Brad Garlinghouse and Chris Larson, Ripple is the sole defendant remaining in the case. After receiving all of the briefs at the conclusion of the case in April, the judge will make a decision in July, and this is the most important part of the discussion. Ripple is the only company named in the complaint. The case presented by the prosecution has been whittled down by the defense to just 20% of what it was initially. How much of it will still be available after the month of July? As a result of this, you only work with the very finest legal counsel. You may also be interested in reading XRPL expresses pleasure over vital NFT upgrade following successful vote on proposal to price XRP. The price of XRP at the moment on the market is $0.66, despite the fact that the BlackRock XRP ETF is a hoax, just like the BlackRock XRP Trust, which was a file that inflated the price of XRP by 15% in less than an hour. This follows the false filing for the BlackRock XRP Trust that was previously done. The low for the past 24 hours is presently at $0.64, and the high for the past 24 hours is currently at $0.74. Additionally, the trading volume has increased by 250% in the past 24 hours, indicating a jump in enthusiasm among traders for contributing to an upward gain. In addition, a well-known cryptocurrency attorney, John E. Deaton, recently shared his thoughts on the ongoing XRP case that Ripple Labs is waging against the Securities and Exchange Commission. He indicated that, in his opinion, any potential settlement worth $20 million or less will constitute an overwhelming success for the law firm's representation of its clients in legal matters. Ripple Labs is the party that initiated the legal action by filing a complaint with the SEC. Deaton vehemently disagreed with any concept that the conclusion of the litigation was just a victory for the SEC. Deaton emphasized that the decision was closer to 90-10 in Ripple's favor. The case from Deaton's point of view regarding the XRP lawsuit was discussed. In reaction to the perception that the conclusion of the lawsuit was merely a victory for the SEC, Deaton's statement was released into the public domain. The comments that Deaton made were a response to a post that was published by Stuart Alderody, who is the chief legal officer at Ripple. Within the context of that article, Alderody brought attention to yet another legal defeat for the SEC. Deaton included the following statement: "The individuals who have contended that the SEC gained a 50-50 victory in the Ripple case are completely incorrect. Ripple won by a margin closer to 90-10 than any other competitor could have hoped for. Ripple will be deemed to have won 99.9% of the legal battle if it pays $20 million or less as the final settlement amount." Deaton's viewpoint is reflective of the sentiment held by the cryptocurrency community as a whole, which largely views the proposed $20 million settlement as a beneficial outcome for Ripple. The contribution to the story made by Stuart Alderoty's writing is likewise important. In it, he said that the SEC was defeated once again this week, thus preserving their losing record. This week's loss kept their losing streak at 7 straight. According to Alderoty, the Court of Appeals for the Second Circuit came to the conclusion that the SEC cannot ask for a crippling disincentive amount before first proving that investors receive significant financial loss. Regarding the matter of SEC Vigoval, this decision was arrived at. In other words, there will be no adverse effects as a result of this. Ripple's fight in the courts in December of 2020, the Securities and Exchange Commission launched legal action against Ripple Labs, claiming that the company had participated in an unregistered securities offering through the sale of XRP, which is the linked native cryptocurrency. The lawsuit was submitted to the United States District Court. According to the allegations made in the complaint, XRP should be regarded as a security and Ripple should have registered its token sales with the Securities and Exchange Commission. In addition to this, the complaint asserted that XRP should be sold on a centralized marketplace. The cryptocurrency market was rocked as a result of this action, since it had the potential to establish a precedent for the regulation of digital assets in the United States. As a result, shockwaves were sent out into the market. Even though the object in question was being traded on a secondary market, Judge Annalisa Torres ultimately decided that it was not a security and thus set a precedent with her decision that the item in question was not a security. The claims that had been made against executives at Ripple were found to be untrue, which was another significant milestone in the case. In the meantime, Judge Torres has just given her consent to an order relating the SEC and Ripple's request to arrange a briefing plan to confer on institutional sales of XRP. The order is related to the request that was made by Ripple. In this particular aspect of the litigation concerning XRP, the corporation was found to be in violation of the securities regulations in question. Ripple requested that this be done by the SEC. The parties were required to provide Judge Torres with a timeframe for the joint briefing by no later than November 9th. In light of this, Deaton drew attention to a fascinating statistic that was mentioned in a recent article. He stated that as of right now, Ripple and the SEC are not engaged in any negotiations on a possible settlement of the dispute. The world of cryptocurrencies has witnessed a considerable increase over the course of the previous year, with a number of different digital coins achieving big advances. It is anticipated that this pattern will carry on. XRP, which is a well-known name in the cryptocurrency sector, recently made an attempt to break past a barrier as indicated by the daily charts. However, a few long-standing problems may make it difficult for this potentially game-changing invention to fully materialize. The fundamental problem with XRP is that there is a conspicuous absence of trade volume and liquidity. This is the first and most significant issue at hand. A robust transaction volume is typically connected with high levels of investor interest as well as robust levels of market activity. This would be bad for the market. The source that was quoted was Trading Perspective. When viewed on a daily basis, the price of XRP has been generally traveling in a horizontal direction with only very little upward or downward changes. That's all for now.